What if I told you the biggest battle over suppressors and short-barreled rifles didn't happen in a courtroom, but inside the Trump DOJ itself? What if I told you that the very administration claiming to be the most pro-Second Amendment in history just filed a brief that could keep suppressors and SBRs locked inside the NFA permanently? And what if I told you the groups fighting for your rights just made their most aggressive legal strike in decades, and the government's response reveals a deeper, far more complicated fight than anyone expected? Because that is exactly what just happened. This case isn't just about a tax being reduced to zero. It's about whether the NFA, a law built in 1934, still has any constitutional foundation left. And the DOJ's newest filing does one thing very clearly. There's been a significant development in the ongoing legal battle over National Firearms Act regulations, particularly concerning suppressors and short-barreled rifles. The Department of Justice under the Trump administration has recently submitted their opposition brief, and their position may surprise those who expected a different approach to firearms regulations. The case centers around what happened after the passage of legislation that reduced the NFA transfer tax from $200 down to zero. This change sparked immediate legal action from several Second Amendment advocacy groups and private companies who saw an opportunity to challenge the remaining regulatory framework. Their argument is straightforward. If these items are no longer being taxed, then the constitutional justification for regulating them has evaporated. Gun Owners of America joined forces with other organizations and businesses to file suit against the Bureau of Alcohol, Tobacco, Firearms, and Explosives. What makes this legal challenge particularly noteworthy is the support it has received from 15 state governments. States including Texas, Alaska, Georgia, Idaho, Indiana, Kansas, Louisiana, Montana, North Dakota, Oklahoma, South Carolina, South Dakota, Utah, West Virginia, and Wyoming have all thrown their weight behind the effort to dismantle what remains of these restrictions. There's speculation that additional states may join as the case progresses. The plaintiffs took an aggressive legal strategy by filing for summary judgment, essentially asking the court to rule in their favor without going through a lengthy trial process. They argue that since Congress originally justified these regulations through its constitutional power to levy taxes, removing that tax eliminates the legal foundation for continued restrictions. Their brief asserts that suppressors, short-barreled shotguns, short-barreled rifles, and any other weapons no longer have a valid constitutional basis for regulation now that the tax has been eliminated. The legal theory goes deeper than just the taxing power question. The organizations challenging these rules contend that the regulatory scheme exceeds the powers specifically granted to Congress by the Constitution. They further argue that these regulations directly violate the Second Amendment's protection of the right to keep and bear arms. Under the Supreme Court's framework established in recent decisions, firearms are presumed to be constitutionally protected unless the government can demonstrate a historical tradition of regulation. The challengers believe the government cannot meet this burden, especially given the changed circumstances. The Justice Department's response reveals that the current administration plans to vigorously defend these restrictions despite the zero tax rate. Their opposition brief presents multiple legal theories to justify maintaining the regulatory framework even without the tax component. This position represents a continuation of how the DOJ has approached similar cases, consistently defending the National Firearms Act against constitutional challenges. One of the government's primary arguments focuses on the fact that while the tax on individual transfers has been eliminated, there remains a special occupational tax imposed on manufacturers, dealers, and importers of these firearms. The Justice Department contends that the registration and transfer requirements for individual items support the enforcement and collection of this industry tax. According to their reasoning, the entire regulatory web serves to ensure compliance with the occupational tax scheme, which provides sufficient constitutional justification under Congress's taxing authority. The government doesn't stop with the taxing power argument. They also invoke the Commerce Clause as an independent basis for federal regulation of these firearms. Their brief explains that these weapons move through interstate commerce at multiple stages, from manufacturing through distribution, retail sales, and final purchase. The Justice Department argues that Congress has broad authority to regulate this interstate marketplace, and the NFA requirements attach at each point in the commercial chain. Interestingly, the government goes further to address situations where the commerce might be entirely intrastate, such as someone manufacturing a suppressor in their own home for personal use without any interstate transaction. Even in these scenarios, the DOJ argues that regulation is constitutional because allowing unregulated submarkets would create gaps in the federal regulatory scheme. This argument attempts to extend federal authority even to purely local activities based on their potential aggregate effect on interstate commerce. The Justice Department also relies on the necessary and proper clause as a catch-all justification. They argue that even if neither the taxing power nor commerce authority alone would be sufficient, the regulatory structure is still permissible because it's rationally related to implementing Congress's enumerated powers. This represents a belt and suspenders approach to constitutional defense, providing multiple independent grounds for upholding the regulations. Perhaps anticipating an unfavorable ruling, the government's brief includes a fallback position on the appropriate remedy. They argue that even if the court rules against them, any relief should be narrowly tailored to benefit only the specific plaintiffs named in the lawsuit. The DOJ opposes any nationwide injunction that would effectively strike down these regulations for everyone. They contend that judicial relief should be limited to curing only the specific injuries alleged by the named parties. Regarding the Second Amendment issues, the government takes an interesting position that varies depending on which type of firearm is being discussed. For short-barreled shotguns and rifles, they rely on older Supreme Court precedents that found these weapons were not protected by the Second Amendment. The DOJ argues these holdings remain valid and that these firearms are dangerous and unusual weapons falling outside constitutional protection due to their historical regulation. The suppressor question required a different approach because of positions the Justice Department had already taken in other recent litigation. In a previous case, the government had conceded that suppressors are indeed arms protected by the Second Amendment. The appellate court accepted this concession while still upholding NFA regulations by characterizing them as a presumptively lawful shall-issue licensing scheme. The Justice Department now points to this ruling as precedent supporting continued suppressor regulations even at a zero tax rate, arguing that being a protected arm doesn't mean an item is immune from reasonable regulation. This legal battle represents just one front in a broader war over firearms regulations following the tax elimination. Multiple lawsuits have been launched with different legal theories and in different jurisdictions. The outcome of this particular case could have significant implications for how courts analyze the constitutional basis for gun regulations that originated as tax measures but have evolved into comprehensive regulatory schemes. The litigation will likely take considerable time to resolve, potentially reaching the Supreme Court given the importance of the constitutional questions involved and the disagreement between the states and the federal government.